Hello and welcome to part 2 of this series about the Indian Child Welfare Act, ICWA. In part 1 of the series, we talked about what the ICWA is, how it was formed in response to family separation within Indigenous communities, and how it currently functions to keep Indigenous children connected to their families and tribes. In part 2, we'll talk about Brackeen v. Haaland, a Supreme Court case that is currently challenging ICWA, how Indigenous communities have responded to Brackeen v. Haaland, and the implications of the Supreme Court's ruling. The plaintiffs in Brackeen v. Haaland are 3 white families, the Brackeens, the Cliffords, and the Librettis, and 1 Indigenous woman, Hernandez, who allege that ICWA is racially discriminatory against non-Indigenous people seeking to adopt Indigenous children. Haaland refers to Deb Haaland, the United States Secretary of the Interior, the department which leads the Bureau of Indian Affairs. The plaintiff's argument is based on the fact that when finding adoptive parents for an Indigenous child, ICWA prioritizes family, members of the child's tribe, or members of other Indigenous tribes. The plaintiffs argue that this aspect of ICWA violates the 14th Amendment rights of non-Indigenous people because it makes it more difficult for non-Indigenous people to adopt Indigenous children. Defenders of the ICWA say that claiming ICWA is racially discriminatory is both disingenuous and dangerous. ICWA protection is based on tribal membership, which is a political, citizenship-based category, not a racially-based category. If tribal membership is reframed as race-based and determined unconstitutional as a result of the decision in Brackeen v. Haaland, tribal law experts say that this could call into question the constitutionality of all laws that rest on tribal membership. Chrissy Ross Nimmo, Deputy Attorney General of the Cherokee Nation, commented in a 2022 The Nation article, "We're talking about laws that apply to individual Indians, possession of eagle feathers, but we're also talking about much broader laws that apply to tribes as governments. So issues like reservation status, land use, water rights, gaming, just any issue that you could ever think about that is a legal issue involving tribes is questionable if a court finds that ICWA is unconstitutional because it's race-based." In response to the Brackeen plaintiffs, approximately 500 Indigenous tribes, 62 American Indian organizations, 87 members of Congress, and 23 states have filed briefs in defense of ICWA. The Supreme Court heard arguments in this case in the fall of 2022 and are expected to deliver a ruling in the spring of 2023. Finally, as we await the Supreme Court's ruling, it's also important to note that this case has illuminated larger issues within the legal system. On the podcast Counterspin, journalist Jen Deerenwater emphasizes that the Supreme Court does not currently require its judges to be trained in Indian law. You don't have to know anything about Indian law in order to graduate from law school, to pass the bar, to serve as a judge, to serve on the Supreme Court. And Indian law is a part of constitutional law. It's part of federal law. We have people graduating, becoming lawyers, becoming judges that know absolutely nothing about this. As a result, we now have judges who aren't trained in Indian law making a decision that could have massive repercussions for Indigenous tribal sovereignty. Thank you for watching.